Ready? Exercise number 30, legal matter, start. Dismissal of workman for reasons other than as disciplinary action has been already covered under the redundancies, business transfers, and section. Stop. For termination stigmatic on grounds of misconduct, an employer may terminate employment without serving prior written notice provided a disciplinary inquiry in accordance with the principles of natural justice has been carried out. That is, the employee has been made aware of the allegations and has been afforded reasonable opportunity to defend the same before an unbiased committee akin to a court hearing. Any propriety in following these procedures can result in reinstatement and back wages. Non-workmen are governed by the terms of the employment contract and are often outside the purview of employment welfare legislation. Stop. Next para. Governed by the relevant S&E Act or the umbrella places of legislation such as Factories Act 1947, etc. In future, more uniformity has been brought on by the courts. The types of leave contemplated are public holidays, annual leave, sick leave, and casual leave. For most states, annual leave is usually 1 day for every 20 days worked, which is usually 12 to 15 days, and sick casual leave being in the range of 5 to 12 days. Public holidays are usually between 8 to 12 days. Carry forward of annual leave is approximately 30 to 45 days. The state of Karnataka has recently increased its carry forward limit from 30 to 45 days. Paternity leave has no legal basis but is an increasing industry practice. For the first two children, paid maternity leave is 26 weeks, while subsequent births allow for 12 weeks. Surrogacy and adoption also allow for 12 weeks of leave. Paid leave entitlements are also available for pregnancy related illness or medical procedures or miscarriage. Further, creche facilities under bracket either in-house or external bracket out need to be provided by establishments with 50 or more employees. The provisions continue to be the same under the SS code. Stop. Next para. Applicable to all employers with 10 or more employees. The payment is made to recognize employees who have been in service for 5 or more years, and the payment is made for any separation from employment under bracket not being stigmatic bracket out at the rate of 15 days wages for every year of completed service. The maximum amount is INR 20 lakhs under the SS code. Gratuity shall be paid to fixed term employees on a pro rata basis, and the threshold for payment of gratuity to working journalists has been reduced to 3 years. Stop. Next para. The Employee Provident Fund and Miscellaneous Provisions Act 1952 requires employers in certain establishments with 20 or more employees to make contributions of 12% under bracket both employer and employee bracket out towards an employee provident fund with the aim of providing employees with retirement benefit. The same is mandatory for employees earning less than INR 15,000 per month but may be opted for by employee earning more. The SS code makes this provision applicable to all establishments with 20 or more employees and has reduced the provident fund contribution from 12% to 10% with options for different percentages to be notified. The Employees Compensation Act 1923 provides for payment of compensation to employees for temporary or permanent disabilities caused by accidents or occupational diseases which have occurred during the course of employment and is attributable to employment. Full stop. Thank you very much.